It cannot be the case that a president of the United States can attempt to overturn an election and seize power, and that our justice system is incapable of holding a trial, of holding him to account before the next election. That cannot be the case. Taking action that will result in further delay in preventing the American people from seeing that evidence in open court is itself suppression of the evidence, that the American people have a right to see that evidence, and the court ought to recognize that.
It cannot be. Hi again, everybody. It's 5 o'clock in New York. Consider two simple questions that cut through to the very beating heart of our living, breathing democracy. The first is the President of the United States above the law? Yes or no? Is the sheer power of the office so absolute, so permanent, that no single act, however foul, is subject to legal scrutiny? We don't know. While that courthouse in Manhattan has so far absorbed our attention these past few days, tomorrow it'll be the Supreme Court that we'll have to keep an eye on as well, making its own bit of Supreme Court history. Opening arguments in Donald Trump's immunity case start at 10 a.m. Eastern. Those 9 justices, those 9 human beings, will evaluate the arguments being made by a disgraced ex-president, that the actions he took in the aftermath of losing the 2020 election to overturn that defeat were actions taken by a president, were official acts. His team will make the argument that those fake electors plot and that attack that turned deadly and threatened the life of Mike Pence at the U.S. Capitol traced back to his duty, his official role as the country's chief executive. He'll argue that it was done to preserve the integrity of the election. Not as special counsel Jack Smith's team has argued, quote, a private scheme with private actors to achieve a private end, the petitioner's effort to remain in power by fraud. Quote, nothing in constitutional text, history, precedent, or policy considerations supports the absolute immunity that the petitioner seeks. Although it will surprise no one that hasn't stopped Trump's lawyers from asserting that he could go so far as to direct SEAL Team 6 to assassinate a political opponent. That's being said out loud now. That's where we are as a country, as a democracy. That is where we are. But even beyond this epic question of the scope of American presidential power is the all-important second question, right? That is, what profound damage has been done? How far away from true north are we as a democracy that this question is being considered at all? No American president, not one, not even Richard Nixon, asserted that a president should have such sweeping immunity. Not even Nixon did that. And yet the man who's making that argument in an attempt to avoid accountability for his actions he barely denies, just so happens to be the current Republican nominee for the office of the presidency of the United States. And then there's the Supreme Court itself. So here's where this gets interesting and tricky for them, right? A body whose popularity among the American people, according to Gallup, has plunged farther and faster than any institution in American civic life. That body, those people on your screen, they denied a request to contemplate this very question from the other side, from the prosecutors. Back in December, Jack Smith sought to fast-track this case so that we wouldn't be where Liz Cheney said we should never be, right? Maybe not having a trial, maybe not airing the evidence in front of the American people before an election to decide, you guessed it, who will be our president. Now, make no mistake, whether or not Trump prevails, this particular appeal does nothing to change the fact that the nation's highest court has already done the disgraced ex-president a solid in terms of the timeline and the schedule. Big favor. They have gift-wrapped an otherwise unavailable delay for him. They've shown the country, the public, the 60% of Americans who don't think much of them anymore, they've shown an ability to move quickly when he asked them to. So here we go. foundational principle under consideration, the future of our democracy at stake. It's where we start the hour with some of our most favorite experts and friends. U.S. special correspondent for BBC Studios and MSNBC contributor Katy Kay is here. Also joining us, RNC spokesman, host of the Bulwark podcast, Tim Miller is here. Back with me at the table, former top official at the Department of Justice, MSNBC legal analyst, the indispensable Andrew Weissman's here. I want to play the SEAL Team 6 thing, so no one thinks I'm just saying that. Here it is.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
With Trump, we should know by now that none of these are hypothetical, right? He always gets to the absolute end of any theoretical hypothetical.
So, you know, it's his right to push these claims. The culprit here is the Supreme Court, and making this sort of a new normal. My colleague Melissa Murray and I wrote a piece today that basically said the Supreme Court has already botched this because they did not take it, as you pointed out, in December. There's no reason to have a stay in effect right now because there's no way that they're going to rule that there's immunity in this case. The only argument I've heard from anybody, even the most conservative legal jurists, is maybe in some small area in dealing with like foreign relations. There may be some area where a president is immune, but it's not this. So there's no reason to have taken the case. There's no reason to have taken the case and stayed the district court case. And so that's the real evil, is that I think what's going to happen is the Supreme Court is going to issue a flowery decision about how presidents are not above the law. It's going to sound great, and they could issue that in June, and it's too late, because what they will be saying is presidents are not above the law, but this former president is. And it's really, I mean, that is so political, and, you know, with a capital P in terms of what they're doing here. When there's just no basis in the law whatsoever for a claim that he's immune with respect to this case.
And what do the most respected defenders of the court, how do you defend, if the argument's one you want to weigh in on, why not take it up when Jack Smith puts it before the court?
Delay. I can't give you a good faith argument. I mean, there's the argument, why not take it up in December? Why schedule this when you finally do take it? Why schedule it for the very last day? Tomorrow is the very last day of the term. They gave 2 months for briefing, as if the parties hadn't fully briefed this in the district court and the Court of Appeals. It could have been heard on an expedited basis. They do that all the time. One of the things that, again, just to be proselytizing for NYU, was my other colleague, Ryan Goodman, and I wrote a series of questions that the justices should be asking the parties. And the key one is Donald Trump is saying that he is immune from prosecution. He is also saying that the D.C. prosecution is interfering with his ability to run for office. So the question to his counsel is, don't you have every reason for us to decide this quickly? Don't you, on the only issue that's before us, which is immunity, not the trial date, that's not supposed to be before us. Isn't it your interest to have us decide this quickly? Or are you saying you only want us to decide it quickly if we're ruling in your favor, but otherwise you want us to take a lot of time? But
that is the practical impact of this. Is there, I mean, do we think so little of them, as does the American people, that we think there's no scenario they decide this quickly enough for Judge Tanya Chutkan to have a trial before the election?
I think it is possible. There's, you know, when I look at the data points here, they don't add up to getting there because, as you pointed out, they could have taken the case in December. Mm-hmm. They didn't have to delay this for 2 months to hear it on the very last day. And so, you know, if I'm looking at the tea leaves, mm-hmm. Are you asking me, do I think so little of them? And am I so cynical? Yes, I think there are 5 justices who are perfectly happy to give this a very, very slow roll.
I'm 10 steps more cynical than you are. I'm just trying to understand if it's possible that and I think that hope is the gateway to despair, so I'm not going to hope for anything. But is it possible? Is it possible to make a decision in a manner that lets Judge Tanya Chutkan have a trial before Election Day?
It is, and it is also, there are a number of things they could do. So one of the things that happens, not very often, but it can happen in the Supreme Court, it happens in the lower courts, is they could say, we are lifting the stay. They could take a vote the day after the argument on Friday. They could decide, we're lifting the stay, opinion to follow. And that lets her go forward and have all the pretrial proceedings.
Just
remember,
with the odds like less than one.
Yes. I mean, in a rational world, there's no reason for the stay to have existed. But let's say you decided you want to give Donald Trump his due in terms of making his argument, then the key point to him is, tell me why there's immunity in this case. And if it's clear from 5 justices that there's no immunity in this case, then lift the stay immediately, let the case go forward. And if you want to write on it, write on it. You can issue your flowery decision. But the main effect, that is the key culprit right now, is the stay. Because the district court cannot do anything. She can't have, and remember, there's an 88-day period that she had promised that there would be sort of 88 days before the March 4th trial date. I can't help but say, by the way, if that case had gone forward, we would likely have a verdict now, sitting here.